Your Honor.
All right, very good. All right, I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of larceny less than $200, the 93-day offense. That's a count 3. Upon his successful plea to that charge, counts 1 and 2 would be dismissed. The defendant is also agreeing to pay restitution in a total amount of $130 without a restitution hearing relating to the victim of Natalia Lovo. And that's specifically as to count 1, but he's agreeing to pay that amount. There's also the prosecutor and defendant are agreeing to a sentence agreement, 93 days of credit for 42 he served. There's a note that the defendant is incarcerated at the Washington County Jail as a result of being sentenced on other cases with an estimated release date.
Right out of the gate, we're looking at a plea deal that dramatically reduces this defendant's exposure. Instead of fighting multiple charges, he's accepting responsibility for a lesser offense, agreeing to restitution, and locking in a sentence recommendation. But here's the question.
Of March 3rd, 2026. That's the court's full understanding of the.
That is our understanding as well.
All right. The one thing I will do on the form without objection is I will check the sentencing judge waiver box. So this is not my case.
Without objection.
All right.
Thank you, Your Honor.
Thank you. All right. You ready?
He's executing the
I thought he was writing work.
rights and rights.
Yeah, have him sworn.
Raise your right hand. Solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
State your name. State your name.
Edward Harris.
All right. Mr. Harris, it is this court's understanding that you are going to be pleading guilty to the charge of larceny less than $200. Is that right?
Yes.
That's a misdemeanor, punishable by up to 92 days in jail, $500 fine plus court costs. Fine could be increased 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
All right. You also understand, sir, that while I'm taking your plea, I would not be the sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. You understand that?
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Right.
Okay. You signed an advice of rights form today. Is that correct?
Yes.
Any question regarding any of those rights?
No.
All right. Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up all of those rights?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
All right. Are you on probation or parole?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
All right. On the date of May 3rd, 2025, at the location of 530 South State Street, City of Ann Arbor, Washington County, State of Michigan, what do you do that makes you think that you're guilty?
What was it?
This is one of the most important moments in any guilty plea. The judge isn't just asking if a defendant is guilty. He's creating a factual record. The court has to establish exactly what happened and make sure the defendant admits every element of the offense.
I committed larceny out of a building.
Okay. So did you take something that wasn't yours?
Yes.
What'd you take?
Backpack.
You took a whole backpack?
Yes.
Okay. And that backpack wasn't yours?
No.
And the owner of that backpack didn't give you permission to take it?
No.
At the time you wanted to keep that backpack permanently in some way. Is that correct?
Yes.
Okay. Okay? All right. Sir, I do have to let you know that if I accept your plea, between the time of my acceptance of your plea and your time of sentencing, that if you commit misconduct as defined by the Michigan court rules, the court would no longer be bound by any sentence recommendation or evaluation. You would not be entitled to withdraw your plea. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other actions which have led to this plea?
No, Your Honor.
Have I complied with the court rule, and would it be proper to accept this?
I believe so, Your Honor, yes.
Yes, Your Honor.
Court, well, you okay?
Yeah, this one.
Okay. Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
November 21st at 8:30 a.m.
November 21st, 2025, 8:30. That's before Judge Perry. All right, Mr. Harris, is this the last case you have before me?
Yes, it is.
Is it?
Yes.
Well, great. I wish you, Mr. Harris, you have been an absolute joy. All right.
Thank you.
Always very respectful in terms of the way that you approached, and you got a good heart.
Thank you.
Okay. Just don't take any backpacks.
I won't.
You won't do that anymore?
No.
All right. But I wish you all the best, since it's the last time I'll see you.
Oh.
It better be the last time. Don't do anything else to come.
It will be.
All right. You take care of yourself.
All righty. Thank you.
Bond will continue.
Thank you.
Right. However, I group it 20, and I believe we're ready to resolve this case.
That's correct, Your Honor. Should be a plea form in front of you.
Yes, I have a plea form in front of me that indicates that the defendant would be pleading no contest to the charge of stalking. That's a count 2. Count 1 would then, that's a 1-year offense up to 5 years probation. Count 1 would then be dismissed. Defendant agrees to complete Accountable Choices, the 52-week level 3 program, and start Accountable Choices while in custody before the pre-sentence recommendation or pre-sentence report. Prosecutor and defendant agree to a sentence of 5 years probation with Accountable Choices per the above. It's not to be released until a pre-sentence report is or a pre-sentence interview is conducted. Agreement to early termination of probation eligible after 2 years if recommended by probation and the program is completed. There have been no violations. Also, the people agreed not to charge an R&O from the court incident of October 14, 2025. That's the court's full understanding.
That's correct, Your Honor.
Right now, I've planned with the council, I told him that we do have defendant's phone. It has been extracted, so if evidence transcript of that phone, we might be looking at a different charges, whether it's for intimidation. That would be separate. That would not be part of this agreement. I want to make sure that that's on the record. That would be a separate charge.
That's correct, Your Honor. I've had an opportunity to review that and discuss with him. And we're looking to enter into this agreement today, knowing that.
So, Mr. Sanders, you understand that if from their phone they determine that there's potential witness tampering types of charges or other charges, that's not contained.
Yes, Your Honor.
Here,
Yeah.
so understand that.
Yes, Your Honor.
One other thing, bond was not addressed within this resolution regarding any agreement with the prosecutor. I know they're not objecting to a release after his PSIR is completed. I don't know right now. I understand his bond was revoked. I would like.
I would leave it as revoked. Let the interview take place, and then lay that in people one.
Okay, and then I'd be able to file a motion fresh hour to amend his bond.
All right, let's have him sworn.
You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Jeffrey Allen Sanders.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charges. That is a misdemeanor punishable by up to 1 year incarceration, $1,000 fine, and up to 5 years probation. You understand that?
Yes, Your Honor.
All right. You understand what a no contest plea is?
Yes, I do.
All right. Two things about it I have to make sure that you understand. First thing is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in 1484 District Court.
Yes, Your Honor.
Basis for the no contest plea.
Civil liability, Your Honor.
So, sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, Your Honor.
You signed any advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
Court has been provided and has reviewed Washington County Sheriff's Office report for their case number 2543124. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon a review of that report, the court does find that there is a sufficient factual basis which the court can determine the defendant's guilt of this offense. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, that the court would no longer be bound by any sentence recommendation or evaluation. You understand that?
Yes, Your Honor.
You also understand that you would not be entitled to withdraw your plea.
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to?
No, Your Honor.
And have I complied with the court rule, or would it be proper to accept this defendant's plea?
Defense is satisfied.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation is ordered at 14 for probation. Sentencing in this matter will be
November 18th, 9 a.m.
November 18th, 2024. Sit with 9 a.m. That is before Judge Freshour.
Thank you.
Thank you, Your Honor.
Bond will continue as revoked.
Thank you.
Joshua Wara.
All right. And this is the date and time I had set preliminary examination in this matter. My understanding is you would like a forensic evaluation.
That is correct, Your Honor. Based on my conversations with Mr. Wara,
Forensic evaluation for what? What's going on here?
based on my conversations with Mr. Wara, I believe that it is necessary.
Hey, I'm representing myself. What are my charges? What am I in here for? I'm representing myself. I don't need a barcode to represent myself. What am I in here for? What charges am I on here for?
What a surprising ending to that hearing. After handling countless defendants, judges develop a sense for who's genuinely respectful and who isn't. The judge clearly sees potential in Mr. Harris, but that final joke about the backpack serves as a reminder that second chances only matter if you actually learn from the mistake.
I don't need a forensic exam. I'm not mentally disabled. I have ADHD and PTSD. I'm perfectly fine. I'm not on Social Security.
Sir, you are before the court on a felony complaint that alleges that on or about, as I read to you before, October 15, 2025, location of South Main Street and East William Street in the city of Ann Arbor, Washington County, state of Michigan, that you did fail to stop at the scene of an accident resulting in serious impairment or death. Individual.
The guy was
That is a
perfectly fine.
felony. That is a felony punishable by up to 5 years incarceration and a $5,000 fine plus court costs. You do understand that, sir?
I understand that. Thank you,
All right,
Mr.
count
Simpson.
2 on that complaint alleges that on that same date and at that same location that you did commit a moving violation causing serious impairment of a bodily function. That's a misdemeanor punishable by up to 93 days, $500 fine plus court costs. You understand?
Yeah, I understand that.
All right. So that is what you are here for.
Mr. Simpson, I'd like to subpoena the camera footage from the mobile gas station there on North Main Street that I was at, or on South Main Street where I was at, over on South Main Street in Maynard. My car was parked there the whole time. I accidentally hit the guy. They hacked the light using an AI.
Sir, Mr. Warren, I'm going to suggest to you this. Refrain from saying anything because anything you say can be used.
Oh, I know. They used an AI ethical hacking app, the Tomboys and the Ku Klux Klan, and they had broken my glasses when I wasn't. They took my car for a joyride and broke my glasses while I was at St. Joe's Hospital.
The Klan did?
Huh? Yeah, the Ku Klux Klan. You can subpoena video records, and I subpoena the security guards from St. Joe's Hospital, Trinity Hospital.
That's one of the reasons, sir. That's one of the reasons why you have an attorney. Did you let them know that?
No, I don't have an attorney. I told them I don't want anybody to represent.
wanna
I said I'm
represent
representing
yourself?
myself. Yes.
Is that what you want to do?
Yes, I would like to do that.
Sure.
And I would like to subpoena
I
the
do
camera
have to
footage from the
advise
mobile
you,
gas station.
now
on
knowing
Maynard.
what the charges are, sir, that if you elect to represent yourself, you'll be held to the same standards as an attorney would regarding the rules of evidence and procedure in the court.
Yes, Your Honor, I
And
understand
would
that.
not be shown any favoritism.
Yes, and I would like to subpoena my
If
discovery
at some
packet,
point in
please.
time you wish then to be represented by counsel, you need to make that request to the court.
Okay. I've
Do-
tried calling the public defender's office and I've tried to tell them I want to represent myself. And I've tried to subpoena my discovery packet and they won't bring it to me. I need to subpoena my discovery packet for all cases available, please. And I would like, yep, and I would like to also subpoena everybody's address in the MDOC that's involved in the Neuralink case through Secretary of State, phone numbers, text messages, and visual voicemail records. And I would like to subpoena the phone recordings, Securus GTL recordings from when I was in the MDOC at ARF level 4 and WCC pictures. And
Sir, I listened to you both through the last hearing and this hearing. So what I'm going to do at this point is I'm not going to relieve the public defenders, but I am concerned, while you have indicated to me that you don't need a forensic evaluation, the court, in listening to you, does believe that you would need a forensic evaluation.
no, I'm perfectly
your
fine,
own-
Mr. Simpson.
Sir, for your own
I'm not on
protection
Social
and
Security.
preservation of your rights.
I'm not on Social Security. I'm over the age of 25. I'm not mentally disabled. I do not need a forensic.
And sir, here's the thing.
I do not
I
go
have
to the
to,
forensic center.
I have to, in terms of these proceedings, make sure that you are competent and
Oh, I'm
can
very
no
competent,
plea.
Cedric Simpson. You can tell. I'm very intelligent. I have a GED. I got a GED in 2013 in 3 months.
Yes, all right.
I got a GED from Washington Community College Adult Transitions Program in less than 90 days in 2013. You can subpoena that record. If someone can get a GED in less than 5 months, I'm pretty sure they're competent. And I would like to
Well,
subpoena my GED from the
you-
Adult
then you
Transitions
can
Program
do
in
that.
2013
You
at
can
Washington Community
draft
College.
a subpoena. I will not relieve the public defender at this point, but I will consider certainly that once the.
Thank you. Yeah, that way, if you,
Forensic
that way, if you see I got a GED from WCC
I
in
am-
2013 in 3 months, you know I'm competent. You know what I'm saying? Thank you, Judge.
I am going to order a forensic evaluation. I will set a competency hearing just to make sure. I'm going to set that for January 29th, 2025,
January 29.
a.m. I will sign an order to.
Can you give me a
the
PR bond, please, Judge?
I'm sorry.
Can I please, I would like to request a PR bond.
This time you can file a motion or somebody can file a motion before the court and I'll consider a written motion, but this time I'm not going to change the bond in this case.
What is the bond?
Currently, your bond is set at $25,000 cash sure.
Do you have any bail bondsman numbers for me that I could get a hold of, please?
Sorry, don't-
I'd like to subpoena a bail
You
bondsman
can
phone
check
number.
with the individuals at the jail. I'm sure they'll be more than happy to assist you in that. right? So that you understand, I'm leaving the public defender on the case at this point.
No, I don't want a
Get
public
the
defender.
evaluation. I hear you. I'm telling you what I'm doing. We will get the evaluation. I suggest that you be cooperative in that. You may be right and come back competent, and then we can get this proceeding moving even quicker.
Not gonna come back, huh? I was gonna try.
Before we go off the record.
People fucked up. You want me-
Okay, keep moving. State your names.
Lori Anderson. Ronnie Martin.
All right. We're here today for a decision on this case, but I'm a bit confused about one thing. Ms. Anderson, you filed a new case for non-payment?
Yes, that was just to make sure for,
Make sure of what?
she hasn't paid, September, October, or, rent, so. I was told to file a
Did
7-day.
you put September in escrow?
No, I have not.
When are you gonna do that?
This Friday.
This Friday. And then what about October?
I'm gonna get that in as soon as possible as well. I don't have a date.
So
I thought I was supposed to,
what?
sorry.
What did you say?
I thought I was supposed to since she was late for rent for 3 months.
Well, if I render a decision on this case, something's gotta be done with that one because this is a non-payment also.
Yeah, it is, sir. I'm sorry.
When is that set for? That's the 8:30 here. My date after that is in what? No, no, this for Tuesday. So here's what I'm gonna do. That case, have you been served on that case, ma'am? A new one?
So, yes.
To come to court on the 7th? All right. I don't know why that was done, but it's now caused a bit of confusion. It's procedure. Yes.
I thought I was supposed to when it was late. I'm sorry if I made a mistake, but
Well, there's an escrow order that's in this case. And you went through a whole hearing on this case.
yeah.
And I'm going to render a decision, but that other case is outstanding. So what I'm going to do is I'm going to let that proceed on the 7th. I'm going to adjourn this case to my decision on this case to November 18th to allow that case to catch up because I don't want this stray case out there. You have the option if you want to, I'm still adjourning this one out to that date, but you do have the option that what you can do is you can dismiss that other case because I don't know what you would get out of that case that you wouldn't get in this case.
Can I dismiss the,
I don't have it in front of me. I don't even know
Well-
who filed it.
can I dismiss this case and just go with this one on the 7th? Since it's for non-payment of rent? That's what I prefer to do.
I'm not going to relitigate this whole case.
I just
That's
want to,
what you want to do.
no, I just want to do it for non-payment of rent. I can dismiss the first case and just,
Well, she's got some counterclaims. You want to just dismiss this case and just go forth on,
Might as well keep going. We've been here since June, so.
oh, I know.
I mean, there's also an outstanding water balance of almost $1,500. So I would just rather cancel this case since I'm the plaintiff and then just go with the 7th.
The water bill she mentioned, she took the water bill out of my name and paid it in full.
It was due on the 6th and they said it would go on my tax bills if I didn't pay
I
it.
don't know why I'm talking about a water bill. This one.
Sir,
What do you want to do? Because you've got this thing all over the place.
I'm going to withdraw this case and just go with the 7th for non-payment of rent. She's 3 months behind right now. And the water bills,
How can she be 3 months behind? She's
September, October, and then it'll be November, and then the water bill of $1,500. So it's well over. She owes a total of $15,000, a little over 15, and she has 6,600 in escrow. So it's getting deeper and deeper. The further we delay it, the bigger the hole gets.
I'm not delaying anything. You keep doing stuff.
Well, I want to withdraw this one and just go for the 7 since I'm the plaintiff on both. For non-payment of rent, that's all I'm concerned.
No, I know. That's why I don't understand the second case.
Well, that's all I want is,
I mean, you think I'm sitting up here and don't know anything.
yeah.
I look stupid, but I'm,
No, you're very smart, sir.
oh, I know that.
I would just rather withdraw this case and just go on with 7.
You let me know when you're done.
Okay, sir. Thank you, sir.
Are you done?
Yeah, I mean, the other attorney,
Apparently not. Go ahead.
the other attorney I was working with before suggested that I do that I withdraw this case and just do the 7-day notice. That's what he suggested. He said that would be easier.
You done?
Yes, sir.
Lyman, what would you like to do? So just so that you understand, if she dismisses this case, what I would do is I would pay the escrow over to her, okay, on this case. Now, no, if you dismissed it, I would be dismissing any of your claims that you have against her. I wouldn't be dismissing any of them with prejudice. You'd be able to raise them in the other one if that's what you choose to do. But that's up to you. And then you'd have to come back on the 7th and we'll see exactly where we are.
I just feel like we should just keep going because this one.
But
Finish it out.
since I'm the plaintiff, don't I have the right to cancel that one, listening to my counsel?
You should have gotten an attorney before you started. But
I know, but he suggested I do. He said,
no, because once she's answered, she has the same right. She can say no.
okay. So if I cancel the one on the 7th, can we just be done with this today? Is that better? I just don't want to keep dragging this on. So if I just kill the one for the 7th and we just,
Ma'am, I can't give you.
well, that's what I want to do.
As to, well, I don't have that case in front of me. It hasn't even been heard. It was filed.
It was just for non-payment of rent, but since you said it overlaps this one, then let's just cancel that one and just do the non-payment of rent on
That's
this.
what I'm going to do. You're going to stop talking.
Okay.
And then I'm going to do what I was going to do at the beginning. And that is, I'm going to let that other case catch up. They're just going to be together because you're elected to file it. Whether, under what reasoning, I'm not even concerned about that. But I'm not going to have two cases standing out in this situation. So I'm adjourning this case for its decision to November 18th. When we get to the other case on the 7th, I will try to have that case catch up with this case. And then we can just decide everything, unless somebody wants to file something else in the end. Thank you.
Thank you.
What time on 8th?
Now,
Are we coming on the 7th as well, sir? Okay. Thank you.